Okay, if the audience could take their seats, once they're done hugging each other, please take your seats.
Yes, sir.
This is the Civil Laws Subcommittee for the Judiciary, formerly known as the Courts of Justice Committee. And could the clerk please call the roll?
Senator Lucas.
Here.
Senator Norment. Senator Obenshain. Senator Boysko. Senator Surville. Senator Peterson.
Here.
Senator Edwards. Senator Deeds.
Here.
Mr. Chair, you have a quorum.
Okay, thank you very much. And Senator Deeds will be sitting over my shoulder, whispering in my ear, and that will be because he is the co-chair of the Courts of Justice Committee, formerly or now known as the Judiciary Committee. The purpose of this subcommittee is to give a hearing on these issues, so witnesses that want to come forward and testify and patrons that need more elaborate explanations, this is your opportunity. Do not save it for the full committee. You will not be heard, most likely. We will just take votes. So having said that, I'm going to look into the audience and see who my patrons are, and I see Senator Emmett Hanger. Senator Hanger.
Thank you, Mr. Chairman, members of the committee. I have Senate Bill 230 in front of the committee this morning. Mr. Chairman, this bill in its current form is what is commonly referred to, and which has been adopted in numerous states, is a Graham-Shop bill, which would extend liability to individuals who serve customers ABC products, where it leaves it up to later judgment from court whether or not they contributed to a situation that might arise later. Mr. Chairman, I'm aware of the controversy, I guess, associated with this legislation, and I'm in a position where I'm possibly going to recommend, actually am going to recommend at the appropriate moment that this bill, I have a substitute that would conform it to Senator Obenshain's bill, and then I would ask at that time perhaps to roll it into
Okay,
his.
well, before we go further, I have a substitute in front of me. Is that the one you want to conform to?
Right, but before I do that, I
Yeah.
would like you to hear Senator Obenshain and I both introduced bills
Okay.
at the request of Dr. Scott Seaton, who's a member of the Board of Supervisors in Augusta County,
Sure.
who lost his wife last year, and he would like to speak to the Graham-Shop bill before I conform it, if that would be permissible.
Sure. Is he in the
Yes, he is
in
here.
the audience?
He is here.
Please come forward, sir.
Hello, Senators, Chairman. Thank you for letting me speak. This is my wife here. She's 49 years old. I lost her last year on April 23rd. Thank you for listening to my testimony of how a drunk driver radically changed my life and my children's and many friends. I'm Scott Seaton, a physician of internal medicine. I was in the U.S. Navy and currently have worked for the University of Virginia for 23 years. I live in Augusta County, Virginia, and in 2019 I was elected to the Board of Supervisors. I want you to know my wife, Ann Seaton. I often joke that when she was born, her shy bone was broken. She never met a stranger. She made friends constantly and invited them home. She was raised in a Christian home on a slim budget with strong values that made her excel in school and in her faith. She had an intense desire to correct justice. If one of her friends was being bullied, she corrected the bully. With her parents and brother, she spent 2 years on the mission field in Jamaica. She could speak, bargain, and even swear in patois. She was known as Ruth's daughter to her friends in Jamaica. In high school, she was on the track and volleyball teams. She played intercollegiate volleyball at Towson State University, where she attended on a Maryland Art Scholarship. Her artistic talents were broad, consisting of watercolors, oils, acrylics, pencil, and carvings. We met in church in Baltimore, and after a couple of months, I mustered up the courage to ask her on a date. After our first date, I knew I wanted to marry her, if only I wouldn't mess up. We were engaged in 7 months and married 10 months later. The Navy moved us to Chesapeake, Virginia, where I finished my residency and was deployed on a fleet surgical team. We fell in love with Virginia and later with Waynesboro. She is the mother of our 4 children. She fought and recovered from postpartum depression after each child, which made her more sensitive to friends who were struggling with depression. She had an infectious laugh that could be heard across a big box store. Besides rearing children, correcting homework, attending games and practices, she had many accomplishments in Augusta County. She was a development director for the Waynesboro Symphony Orchestra, which is nationally recognized for the music it produces. She was a member of the boards for the Wayne Theater, YMCA Waynesboro, Hospice of Shenandoah, Woodrow Wilson Rehab Center, and Boy Scouts of America, among others. She was continually active in our church. She taught many organizations how to have fun and raise money. With her reputation in sales, she landed a sales job. Her boss would tell us that she could sell a burning house. She loved her family, job, church, friends, and community. She didn't worry about trivial differences when people had so much in common. Her cheerful outlook made people look forward to tomorrow. She was generous with her time, counsel, and gifts to encourage friends and family across the political spectrum. I worked hard to support her generosity. We were married for almost 30 years. I loved being her husband. She was the kite and I was the rock to which she was anchored. I never gave her one gray hair, never doubted my love for her. On April 22nd, my daughter told us she was pregnant with our first grandchild. My son asked her to host his friend's bachelor's party on the 24th. Later in the evening of Friday the 23rd, she shopped for groceries for the party. On her way home, she stopped at a red light. When the light finally turned green after other cars had turned next to her, she proceeded through the intersection. A drunk driver, Sean Webster, had just been drinking at a local deli and pub. He left the pub to return to his hotel and drove the wrong direction. He collided with a woman who was exiting from a road near her home. He left that collision afraid of arrest because he was already out on bond for other alcohol-related charges in Virginia Beach. He drove his disabled vehicle back toward his hotel, gaining speed over a hill, and with his lights turned off, he entered the intersection at 10:24 p.m. and T-boned my wife's car, killing her. He was just sentenced last week, having pled guilty. The judge described the collision as shocking to the conscience. I had gone to bed early that evening and was awakened by a loud rap on my door by Augusta County Sheriff Donald Smith, who told me that about the collision and my wife was dead and the drunk driver was in custody. My daughter is in the Army with her husband near Tacoma, Washington. I called her. No one should have to hear.
Take your time.
No one should have to hear the squeal of a pain I heard from my daughter when she learned her mother was dead. I left it up to the police to notify my 3 sons who were at school and my wife's parents, as I didn't want them driving late at night. My sons and daughter came home, and as I slipped into emotional shock, all my senses were altered. My daughter and oldest son had to make the decisions because the wall of grief was too high, and for me to understand what was being asked. At the funeral, I knelt before her coffin, stroked her hair and hands, patted her chest, and apologized for not keeping her safe. She would miss the infirmities of aging, of cancer, of watching me age, and of arthritis and pain. I wanted the chance to take care of her if she were to become sick and hold her when she took her last breath, because I know she would do the same for me. I cannot describe the void created by losing my wife. Without my faith, I don't know where I would be. Nothing or no one can replace Anne. She was a precious gift shared with me. Her life was not about what she did about sharing, but was about sharing, helping, encouraging people, and making wonderful memories along the way. I'm asking you to support this civil liability legislation. This bill is about preventing drunk driving and who will pay the cost of prevention. As of 2018, in the Commonwealth of Virginia, my wife's story of senseless death from a drunk driver was repeated 278 times. Close to 20,000 people were convicted of driving under the influence in Virginia. Nationally, drunk drivers account for 29% of all traffic fatalities. Many of these life-ending or maiming collisions are avoidable, but only if our legislators and governor act. Virginia must enact legislation that reflects the impact that drunk driving has on the Commonwealth's citizens and those visiting our state. In other states, this legislation has caused establishments to be more careful and insurance companies to educate employees to identify intoxicated or underage individuals, which in turn reduce drunk driving and deaths. This will reduce the number of fatalities caused by drunk drivers in Virginia without significant impact on business. Cheaper insurance should not be exchanged for the lives of so many Virginians. This incident has been nothing short of devastating for our family, friends, and community. She became a grandmother earlier this month. But a dream of holding her grandchild was stolen from her. She was a bright light for everyone around her. God gave her wisdom, joy, enthusiasm, and a gift for bringing people together for community improvement. To honor Ann Seaton, I'm asking you to reduce drunk driving deaths by voting for this legislation. Most states have some form of civil liability, and if you talk to people, most assume Virginia has it also, but we don't. Virginia is surrounded by states that have passed this type of legislation. And thank you for listening to the story of my wife, Ann Seaton.
Thank you, Doctor.
Mr. Chairman, as I mentioned, and we've discussed this, and I've discussed it with numerous people, there is significant opposition to the legislation that's drawn. It started out with a bill essentially identical to Senator Obenshain's, and I think you have a substitute in front of you that I'm going to offer to get a small piece in the right direction, I presume, and I would offer that substitute.
I move the substitute.
Okay, so we have the substitute in front of us, and just for the audience's sake, this basically it has the cause of action targeted at negligently furnishing alcohol to a person under the age of 21 who's visibly intoxicated. So the substitute, all in favor of adopting the substitute. This is not a vote to pass. Adopting the substitute, say aye.
Aye.
Opposed, nay. So the substitute is before us. Senator Obenshain, is this also your bill?
That is exactly my bill.
Okay, and what's the number of your bill?
555, I believe.
555?
Right. Mr. Chairman.
Yes, sir. Senator Obenshain.
Yeah, if I can, let me just point out that this bill, as it's amended, this substitute, it is very, very narrowly drawn. There are more than 40 states that have dram shop liability to various degrees. And I know that we don't want to throw the door open in Virginia. So what this does is it creates liability for licensees, okay? Not upstream, but restaurants, bars, convenience stores, licensees who are selling, but only if it is proved by clear and convincing evidence that they sold to a visibly intoxicated minor, okay? This is not broad liability. This is folks who are selling alcohol illegally to visibly intoxicated minors. It also includes a safe harbor in which the defendant, the licensee, can show that they engaged in good practices, which would be admissible to show that they were not negligent, like carding, just training employees. These are evidentiary facts that would be admissible to show that they were not negligent, and creates, to a certain extent, a safe harbor. So that's the limited scope of this bill.
Okay, I've got a question here from Senator Norman.
Thank you very much, Mr. Chairman. I would ask Senator Obenshain, I'm not very astute at reading draft legislation. Can you explain to me what paragraph 2 means?
What's paragraph 2 where?
Oh,
25?
B2.
Line 25.
B2.
I'm sorry, line 25.
Line 25, B2.
Right. That is that's the liability provision in which, or I guess the proximate cause provision, an aggrieved party, which is the person injured or the family of the person killed, has cause of action. Number one is if the licensee negligently sold, And number two is the proximate cause provision that the consumption of alcohol caused or contributed to, in whole or in part, which is essentially was a proximate cause of the crash involving the underage driver who had purchased the alcohol.
Okay. All right, why don't we do this?
Madam Chair.
Thank you. Why don't we move to speakers in support? We've heard from Dr. Seaton. Who else do we have? Mark Dix. Oh, I'm sorry. Yes, we just did. Mark Dix.
Good morning, Mr. Chair. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill. As Senator Obenshain noted, this is a very narrowly tailored bill, only dealing with the most egregious of cases, the over-serving of visibly intoxicated minors. We believe this is a coextensive part of the General Assembly's efforts to curb hazing. Hazing doesn't just happen behind the closed doors of a fraternity or a sorority. Oftentimes, these establishments can be the situs of pledging events, and we think that this is a natural extension of those efforts. Lastly, I would note that there's been some misinformation. Well, this is already illegal. It very well may be illegal, and it's certainly an administrative violation of their ABC license, but right now, as has been mentioned, there is zero civil culpability for these kind of
Okay,
actions.
fair enough. Let me ask you a question. Obviously, if you serve underage, you'll lose your ABC license if you're found. I mean, I've represented clients that have lost their license because they served underage negligently, or in some cases not negligently, they just didn't have a program in place. Is there a negligence cause of action right now without the statute?
No.
And that's because of proximate liability? I mean, proximate cause, or what's the theory there?
It's common law, I believe, dram shop immunity.
Okay. All right.
Thank you.
Senator Norman.
Mark, I'm looking on lines 23 and 24, and I'm wondering, after the word intoxicated on 24, just to be safe on our legislative construction, do we need to add the word "and" so that it's clear that this is all written in the conjunctive? Because I noticed on paragraph 2, it ends with the word "and," which would suggest that it certainly picks up paragraph 3.
I think the answer to that may be yes, but I will ask Kristen.
Mr. Chairman, just the drafting conventions, when we have a whole list of factors, we only put an "and" at the end of the list.
Okay. All righty. Do we have anybody else to speak in support of this legislation, and that's Senate Bill 230 or 555? Okay, opposition. You can make an announcement.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
Did we have anybody on Zoom who was in support?
No, Mr. Chair, there
Okay.
wasn't.
All right. Tom Lisk, please go ahead.
Thank you, Mr. Chairman, members of the subcommittee. Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. And what happened with Mrs. Seaton is tragic, but nothing in this bill would have avoided that situation. This bill does not address that situation.
Mr. Chairman,
Senator Obenshain.
Tom, wouldn't Senator Hanger's bill, as originally drafted, have addressed that situation?
I would argue no, and I'll tell you why. I think the bills are flawed in the basic concept. They seek accountability for those who provide alcohol, whether it be to an intoxicated individual, to an underage individual, the broader bill to any individual if it was negligently served, but only targets a small population of those who provide alcohol. It targets retailers. It targets retailers, whether it be Costco or your mom and pop grocery store or a small restaurant. Omitted from this bill are banquet licensees, which by the Attorney General's opinion from many years ago are not retailers. So whether it be a wedding reception that you get a banquet license for, whether it be Friday cheers or Innsbruck after hours, the big festivals that sell millions of dollars of beer, they're not included in this bill.
Mr. Chairman?
Senator Obenshain.
So, Tom, if we struck retail, would you be happy?
No, and I'll explain to you why.
Line
All right,
16?
let's just let him finish his speech.
Yeah.
Thank you.
It omits, arguably, manufacturers, distillers, wineries, breweries that have retail privileges but are not retail licensees under Virginia law. It omits the Virginia ABC stores, the hundreds of stores around the state that sell distilled spirits. They're not included. In fact, excluded from this bill are 74% of this, which is 74% of the source of alcohol to underage people, come from non-licensees. It comes from friends, older siblings. It comes from parents who either provide it or the underage person steals the alcohol. But 74%, according to the Federal Trade Commission, of the alcohol procured by underage people come from non-licensees. So what this bill will do to licensees, and only to retail licensees, is raise their insurance costs. Now, you're looking for accountability. They have accountability now. It is a Class 1 misdemeanor to negligently serve someone alcohol, whether they're intoxicated, whether they're underage. That's 1 year in jail and a $2,500 fine. The ABC revokes licenses when there's negligent serving. I've had clients that had their license revoked when there was a tragic accident after negligent serving. This is not an exception. So I would tell you they have accountability now, that this will not prevent drunk driving. It will just simply raise insurance costs. And in fact, I think there's greater accountability in the face of a business losing its business than having to pay insurance and a settlement. And for those licensees that do all the right things, they still will incur the entire insurance costs. They still will be sued. They will still have to defend themselves, even if they do all the right things, because the lawsuit will be brought anytime there is an accident.
Mr. Chairman.
Got a question from Senator Servell, then Norman. Servell.
I mean, Tom, I'm looking online at how this, about other states, and it looks like every state surrounding Virginia except for Maryland already has this, and it looks to me like likely a majority of the states, are probably about 80%, and maybe 70% of the population of America already has dram shop liability. So, I mean, is this such a massive problem? California does not, apparently, but it doesn't seem to be a partisan divide on which states have and which don't. But in any event, I mean, is this such a problem, all these like crazy lawsuits and problems in other states? I mean, I've never heard of that.
Well, what I say to you is those states have higher insurance costs for business, but they still have drunk driving. It is not a cure for drunk driving. It does not stop someone who's going to be negligent from being negligent. It just means there will be an insurance company to pay out a fund to the injured party, rather than, as the Virginia Supreme Court has said repeatedly, it's the act of consuming the alcohol that is the cause of the injury. It's not the service of the alcohol. Now, the legislature is free to change that. The legislature on many occasions has chosen not to. You can choose to go in a different direction today, but on behalf of the restaurant industry, we'd encourage you not to do so.
Okay. Senator Norman, and then I want to get to Greg, so Senator Norman.
Thank you, Mr. List. Two questions. Down on line 24, a person under the age of 21, just by way of background, as you know, I live in a college community, and the ability to obtain false IDs is very simple. You can go on the internet and print them out, and they're absolutely prolific. Will this cover an individual who produces an ID that they are 21 or older, but it turns out, in fact, they are underage?
Well, I'm fear, Senator Norman, that will end up being a jury question.
Okay.
The retailer will still be sued, even though it is a perfect fake ID, which are being produced in China routinely and sent to college campuses around the country.
My second question, Mr. Chairman, my last one, the last two words on line 24, visibly intoxicated. I ain't much of a lawyer, but I know a little bit about this area of the law. What is the objective criteria that a retailer would have to exercise to determine that someone was visibly intoxicated?
Well, there are a number of factors, but I think anytime you will talk to a police officer that says someone is visibly intoxicated, they'll say there was alcohol in the breath and bloodshot eyes, which could be a sign of someone who has not slept, but they've had a drink, but they're not intoxicated. But ask each individual, each retailer to decide that. And I just also offer, also excluded from this bill is delivery of alcohol to the home. If I deliver a six-pack from Publix to someone's home, to an underage person who's intoxicated, and that six-pack sits in the refrigerator for a week and then they drink it, they're still culpable based on this law.
Thank you, Mr.
All right. Greg, why don't you come forward, please?
Thank you, Mr. Chairman, members of the committee. Greg Habib from Gentry Lock. I'm here on behalf of VASHUA. VASHUA is the Virginia Asian American Store Owners Association. We have 1,200 members with 2,500 stores and over 12,000 employees. Let me first say what an extraordinarily horrible situation this legislation arises out of with Dr. Seaton and his family. A lot of you here, myself included, have litigated cases like this. These are the most gut-wrenching cases you can possibly have. There's nothing more terrible than have a mother taken from her family with no warning, no preparation, and in such with such obvious right and wrong. There's a good guy and a bad guy, and there's black and white. But when we make legislation, it's really hard to draft bills that prevent the worst cases from happening. What you all have to do is create policy that makes the Commonwealth better. And so I just want to make a few points at a high level and then a few points with the bill. As Senator Servell noted, lots and lots and lots of states have dram shop laws. I'm not aware of a single data point that says states with dram shop laws have lower incidence of drunk driving, lower incidence of fatalities, lower incidence of litigation. They do have higher insurance premiums. We do know that. Don't get me wrong, I will never, ever balance insurance premiums versus a life. If it were binary, you choose life every time over insurance premiums. There's just no evidence that these types of bills lead to less harm. As Mr. Lisk said, this narrowly targets one group of people, retailers. These are the people most responsible when it comes to alcohol. Their licenses are at risk every single day. It is a crime for them to sell to visibly intoxicated people. They are heavily, heavily regulated. If you've litigated these cases, I know several of you have, frequently when an underage intoxicated person is driving, they don't get the alcohol from retail licensees. That's not where it comes from. It comes from family or friends, or it's stolen, or they get it at a party. That's where they get the alcohol from. Now, is that universal? Of course not. There are retail licensees that break the law, and when they do, they lose their license. If they sell to a visibly intoxicated person, they can be charged for that. I don't know why this is just targeting retail licensees other than the obvious attempt to make it as narrow as possible, to make it as sympathetic possible for passage purposes. I understand that. The problem is it then doesn't actually address the problem. It doesn't get to the story we've heard, and it doesn't get to many of the other stories that we have heard. Let's talk about some problems with the actual language in the bill, if anybody wanted to address language in the bill, and why I think to the extent you want to go down the dram shop route, it's going to take a lot more than this session to fix it. The language applies to agents, but it doesn't require them to be acting in their agent capacity at the time this happens. It just says an agent. If you are somebody's agent, that exposes you to liability for actions happen even when you're not acting in your agent capacity. There's no limitation there. It doesn't apply to other licenses. Senator Obenshain referred to a safe harbor. It's actually just an evidentiary provision. It's not an affirmative defense. It's not a get out of jail free card. It's simply evidence. It doesn't actually require a jury to make any kind of finding following that kind of evidence. As Mr. Lisk says, it just creates a jury question. Well, there's always a jury question on negligence. And so what this bill does, it just enumerates some of the stuff you can offer as evidence. It's not an affirmative defense. It's not a safe harbor of any kind. It doesn't exclude when the injured person, the aggrieved person, is in the vehicle. Most of you who have tried these cases know frequently the plaintiff in this case is actually a passenger in the drunk driver's vehicle. These are frequently one-car accidents. That's not the facts here, but of course that is often the case. If you try these cases, you know there's assumption of the risk and contributory negligence issues that arise. The bill doesn't address how you would resolve those questions in this case.
Greg, can you get to the finish line?
Real close.
Okay.
Let me hit one more issue.
All right.
Joint and several liability is a really dangerous concept here, because what this does is even if there's uneven culpability, it applies equal liability to both parties. For the non-lawyers, joint and several liability means we, the retailer, are liable for 100% of the damages. So we sell one beer to someone who does all the things we just heard, who is clearly grossly negligent, reckless, way into punitive damages. We're now jointly and severally liable for all of that. There's no requirement for even culpability. For that and a number of other reasons, we think the bill needs a lot of work. We don't think this is the step we should go down. Retailers are already held responsible and accountable. And so we oppose the bill while understanding how tragic this situation is and how sympathetic the facts are.
Okay.
Thank you, sir.
Thank you, Greg. We've had 30 minutes on this bill, which is fine. Come forward. Please just keep it under a minute.
Mr. Chairman, members of the subcommittee, Sarah Thomas with Vector here on behalf of the Restaurant Association of Metropolitan Washington. Just wanted to express our opposition and echo the concerns of Mr. Lisk. Thank you.
Thank you. Yes, next speaker.
Good morning. My name is George Hodson. I'm the president of the Virginia Wineries Association. I'm the president of Veritas Winery in Afton, Virginia. So we were intimately aware of this incredible tragedy. I wanted to just speak on the criminal statutes in place that are extreme motivators of our training of our staff, that our staff understand the importance of the liability that comes back to them as servers, but then additionally, the opportunity for us to lose our license and lose our business.
Would
So this
you,
has a
let me
huge
ask you a
impact.
question.
Yes, sir.
And I represent a lot of restaurants up in Northern Virginia. Would you agree with me that losing an ABC license is typically a death sentence for a
It would
restaurant?
be a death sentence to a winery if they lost their ABC license. So, and that's what I wanted to express. So thank you very much.
Okay, thank you. Okay, anybody else either to speak in support or opposition? Do we have anybody on Zoom, Sean?
Mr. Chairman, there are no hands raised at this time.
Okay, all right, we've been talking about this for 30 minutes. We've had some excellent testimony
Mr. Chairman.
on both sides. Yes, Senator Servo.
Thanks, Mr. Chairman. So, obviously I represent a lot of people both sides of this issue, and I just want to note that my father never got to know his grandfather because my great-grandmother, his grandmother, because my great-grandmother was killed by a drunk driver in 1936 in South Carolina. And, this is a problem that's been going on for nearly 100 years or probably more, and without us doing anything about it. And, I'm sensitive to the liability piece because our liability system has helped to resolve, or helped to, I think, provide better justice to people and incentivize the correct behavior. I would just note that I think that lines 22 through 29 can be reduced to one sentence. And I wrote a sentence really quick that just says, any licensee who knowingly or negligently furnishes or sells alcohol to a person under the age of 21 is liable to any person injured as a proximate cause of the consumption of such substance. And I don't know why we need to have all these other words in it, but that to me is
Do you want to offer that as an amendment?
I'm happy to. I didn't send it to Charles
you
or
happy to, or
Kristen,
you
but I
gonna make the
can.
motion?
Yeah, okay, fine. I'll make the motion to,
Okay.
and I'll email it to Kristen, I guess.
Okay, so this would expand it from retailers to all licensees.
Okay, fine. If you want to make it any retail licensee who knowingly or negligently, take that as a friendly amendment.
Well, it's not my amendment.
Okay, I'll make that friendly amendment then.
Okay, can you state it for the public so we know exactly what we're doing?
Any retail licensee who knowingly or negligently furnishes or sells alcohol to a person under the age of 21 is liable to any person injured as a proximate cause of the consumption of such substance.
Okay.
And that would replace lines, would be the new subsection B.
That,
Okay, hold on a second. Senator Obenshain, Senator Hanger, it's your bill. Do you accept this amendment?
well,
I would defer to Senator Obenshain, but I also, as y'all do this, would like my bill rolled into Senator Obenshain's, and he listed as chief patron, says I'm feeling pretty positive about this coming out of here, and I don't like to go in front of the House committee.
I was going to suggest the opposite approach, but
All right, well,
You know,
we've
the-
got to, why don't we do this? Before we roll these in, let's just see where we are.
well, on that amendment.
Yeah, where are you on the amendment?
I appreciate Senator Servell's offer of assistance, but it expands the scope of this bill pretty significantly. We tried to draft this as narrowly as we could. This takes out the visibly intoxicated provision and takes out the rather narrow proximate cause provision. I just, I don't know what the future holds for this bill. This is one that's been vetted, or at least most of this language over a number of years. I'd be happy to continue to discuss it with Senator Servell if it moves forward, but I'd just soon not
All right.
make a change.
Okay, so.
Yeah, I'll withdraw the amendment.
All right, so the amendment's been withdrawn. The bill's before us as it is in the substitute, and this is basically the Senate.
Well, Mr. Chair, I'll move to.
Roll them together.
Roll them together.
I'll second that.
Our chief will take-
All right,
We can make a recommendation that the full committee.
okay, so we have a recommendation that they be rolled together. And a motion and a second. All in favor, say aye. Aye. Any opposed? No. Okay, so they're rolled together. So we have both bills physically together in the substitute form. Does somebody want to make a motion on it?
I would move to report, or recommend reporting, if I can speak to it.
Please do.
Very briefly. This is an incredibly important issue. It hasn't been discussed before this General Assembly for a long, long time. 40-some states have some measure of dram shop liability. This is, the advocates who very ably stepped up to the podium and addressed the shop of horrors that this will visit upon the Commonwealth of Virginia have been very effective in keeping this issue from being discussed over the past 5, 6, 7 years, and I salute them for their effectiveness. But this is really indefensible conduct, selling alcohol to visibly intoxicated minors. And I don't know that this could be drawn any more narrowly. And I would respectfully submit that while this wouldn't have saved Ann Seaton's life, this is something that is going to cause licensees to be a little bit more diligent in their efforts to police their customers. And accordingly, I move that we recommend.
Okay, we have a motion. Is there a second?
Second.
Okay, we have a motion and a second. I want to speak to the bill, and probably I'm not the only person up here. I've represented both as a trial attorney, as a plaintiff's attorney. I've also represented establishments that lost their ABC license due to, in some cases, what were just omissions, or sometimes they did nothing wrong. It's just somebody bought underage and they got busted by the ABC. I tend to think that the ABC, amongst all our state agencies, may be the best run. I've always been impressed by their professionalism. Sometimes they can be overzealous, but that's sometimes what the cause requires. I will tell you right now, representing a lot of small businesses in Northern Virginia, like I said, if you get on the wrong side of this issue and you lose your liquor license, you're done. You're done. And you bought a business for $500,000 million, its money's gone. And so I think that is the biggest threat of all. So I regretfully cannot support this legislation. All right, can the clerk open the roll?
Senator Lucas.
Or do you want to just have us vote?
We can do it by voice or by roll call at the
prerogative
of the chair.
Do it on the board, please.
We cannot do it on the board, pardon me. It's a paper roll call vote.
Okay.
By voice in subcommittee. I don't have.
Roll call's fine then. All right, I'm learning.
Apologies, Senator. Senator Lucas.
To vote in favor of the bill, no.
Senator Normant. No. Senator Obenshain. Aye. Senator Boysko. Aye. Senator Serval. Aye. Senator Peterson.
No.
Senator Edwards. Senator Deeds.
No.
Ayes 4, noes 4.
Okay, so we basically have a split vote. It will be voted on by the full committee. We will not have a second level of presentation. I want to thank the people that testified, particularly Dr. Seaton. We gave this, we spent a lot of time talking about this even before today. So I thank you for your very careful consideration. And we'll see you at the full committee. All right, Senator McClellan, I think you're next.
Good morning, Mr. Chair. I have two bills. I'll take Senate Bill 486 first. This is the Workplace Violence Protective Order that was heard in full committee and referred here. And after listening to the committee, we worked with Charles on a substitute that I think accomplishes the purposes of the bill without creating unintended consequences or confusion. And so what the bill now does is just clarifies that for purposes of protective orders, that a petitioner includes an employer whose employee has been subjected to an act of violence, force, or threat in connection with employment.
All right, I appreciate that. And do I have a motion to adopt the substitute? All in favor, say aye. Any opposed? Okay, so the substitute is in front of us. The substitute basically dramatically simplifies by just defining the petitioner as including an employer whose employee has been subjected to an act of violent threat or connection in connection with his employment. So if, for example, you have someone standing outside your door threatening your employee, I, as the business owner, could go to court and put a stop to that.
That's right.
Okay, I like that.
Mr. Chairman?
Yes, sir. Senator Serville.
I mean, I agree with the intent of the bill and what we're trying to accomplish, but, I mean, sometimes people don't make threats to people. They make threats to the actual business itself or to hurt people at the business, but not a specific person. So, I mean, would this definition capture that type of scenario?
I suppose it depends on the nature of the threat. If someone threatens to blow up the building, then I would think that would be a threat to an employee.
Yeah.
Several employees, as a matter of fact.
Yeah, and I also, if somebody threatens my business by saying your business sucks or I'm going to put you out of business, that's a different cause of action.
Right.
That's not a physical harm.
Yeah, I'm not, Mr. Chairman?
Yes, Senator Serville.
And that's not, I'm not talking about that kind of threat. I'm talking about, the kind of threat that Senator Klon just identified. And I don't know, I just know some these things are quasi-criminal and they're read narrowly, and I could see a judge, saying he didn't threaten a specific person. I mean, these are criminal defense lawyers who largely defend these things. They're going to make those kinds of arguments, so.
All right, I'm not quite sure if there's any opposition here. Is there anybody opposed to this bill in this extremely reduced format?
For those attendees in the Zoom who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chair, we do have 2 hands raised.
In opposition, okay, let's hear it. To the substitute. All right, well, let's go ahead and hear, and again, let me just reiterate, and I have heard from people that were not fans of the original bill, but this is really dramatically reduced, so.
Shashila Varkey, please unmute and begin your testimony.
Good morning, Mr. Chair and members of the subcommittee. I'm Sushila Varkey with Virginia Poverty Law Center, and I work on domestic and sexual violence victims issues. So while this substitute is much more narrow, it still allows for example, an employer to get a protective order on behalf of a victim who is not able to get one for herself because they're concerned, that victim is concerned that getting that protective order could actually endanger that person more. So we're concerned with potential coercion by the employer to force that victim not only to out themselves as a victim, but to get that protective order on behalf of themselves when that might actually make things worse.
Okay.
We know that sometimes victims who know their respondents have firearms choose not to get protective orders because the protective order would take the firearms away from that respondent. So while this is much better in its narrower form, it still has the same unintended consequences for a domestic violence victim. Thank you.
Okay, thank you, Shashila. Jonathan.
Yes, good morning, Mr. Chairman, members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We very much appreciate the limited nature of this substitute and agree that it is a bit more focused in its intent. But agree with Sushila and Virginia Poverty Law Center that this may serve to remove the agency that victims have or should have in the petitioning process for a protective order and grant that power to someone else, in this case, the victim's employer. And so any bill that intends to do that or has the unintentional consequence of doing that, we believe is contrary to safety and agency for victims.
Thank you, Jonathan. Anybody else in the audience? And we did have a very full hearing at the full committee, so Chair will entertain a motion. Okay, a motion to
Mr.
report.
Chairman, I'm sorry, I have another question.
Okay, make it quick, because we had
Sorry,
a full hearing on this.
I get it, but I do these every day, and I'm just concerned that, I know what Mr. Qualiato was trying to solve by drafting it the way he did, but if you read 152.10, which is the actual protective order statute, it says the order can only be granted to protect the health and safety of the petitioner and the family or household members of a petitioner. It doesn't say anything about employees. And so it seems to me if the intent is to cover the employees, that statute also needs to be amended to make it clear that the order can prohibit acts against the employees of the petitioner, because corporations don't have family or household members, and an employee isn't the petitioner. And so I'm just concerned that the relief we're trying to get should probably cover the employees. So I think,
but isn't that the whole point of this statute? Is we're expanding the definition of petitioner to include? Yes,
If I-
Senator McClellan.
Yeah, 2 quick points. One, to address the testimony we heard, that's why we put in that it's for acts of violence against the employee in connection with their employment. Second, that is also why the intention is not to extend this to family members of employees, because it is supposed to be acts that could happen in connection with employment at the place of employment. If Senator Surabel thinks we need to amend the other statute to clarify that it's for employees, we're happy to do that. But I think the way that this statute is written now covers the situation we are trying to cover without unintended consequences.
Senator Surabel.
It doesn't. I'm going to have a field day defending this if that's what the statute says, because every time, if I get one of these, I'm going to say, you can't cover the employees. There's no statutory authority or jurisdiction to pick up the employees. You can only pick up the employers like place of business, because it doesn't say anything about acts against employees. And I didn't say anything about, the employees' family members, just, it doesn't say employee in 152-10.
Mr. Chair, that's what the original bill did, and the committee didn't like that. And what we are trying to do is deal with the situation that currently is not covered if someone threatens employees at the place of employment, to give the employer the ability to do something about it.
Mr. Chairman?
Yes,
That's not what the original bill did. The original bill created an entirely new statute, and the committee was concerned you're putting a whole bunch of new words in the code when you only needed to put about 20 words in the code. And so that, Mr. Chairman, is what I was just suggesting, is we just need to add the word employee to 192,
Okay, so
152.10.
I think what you're saying, Senator Surabel, is you want a petitioner could include both the employee or an employer who's.
No, Mr. Chairman.
What? I'm missing it then.
The code section I'm talking about is not in front of you. You have to use your computer to pull it up. But 19.2, 152.10 is the statute that describes what a court can do for a protective order. It's not the definitional section. It's the section that talks about the order. And 152.10 says the court may issue an order pursuant to this section to protect the health and safety of the petitioner and a family or household member of the petitioner. It needs to say petitioner, petitioner's employee, and a family or household member of the petitioner. That part needs to have employee added throughout it to make it clear. That's what I'm saying.
I am happy to accept that as a friendly amendment if the committee feels it's necessary.
All right, are you making an amendment?
I'll make the amendment. I think Charles can figure it out.
Okay, can you restate the amendment just clearly? I've got 19.2 in front of me.
19.2, 152.10, which is the non-family member to protective order statute. I just want to make it clear that
Got it.
when it talks about issuing protective orders to protect the health and safety of the petitioner and family household members, that it can also, that needs to say that it can prohibit acts of violence, threat, blah, blah, blah. It needs to say to petitioner, employee, and a family or household member. And then there's some other places in here, it looks to me like it might need to say employee.
So
but I gotta look at it
basically what
further.
you're saying is you'd need to conform 152.10 to match this new language.
Yes.
Well, no, because it just pulls petitioner
Okay,
from the
if you're gonna answer
definitional
every
section.
question to a no, I mean,
It just needs to add the word employee in 19.2, 152.10 to make it clear that the order can cover employees of the petitioner.
Well, fine. If the committee wants to
are
do
you making that
we'll-
motion?
Yes.
Charles, do you understand that?
Yes, Mr. Chair.
Okay, we have a motion. Is there a second? Okay, we have a motion and a second to basically amend 152.10, which is the statute on protective orders, to effectively marry up with this new language we're adding in 152.7:1. All right. Okay, all in favor of the amendment, say aye. Any opposed? Okay, the bill has been amended. We have a motion to report the bill as amended, or recommend reporting to the full committee. Is there a second? Okay, we have a motion and a second to recommend as reported. Clerk, call the roll.
Senator Lucas.
Aye.
Senator Norment.
Aye.
Senator Obenchain. Senator Boysko. Senator Surville. Senator Peterson.
Aye.
Senator Edwards. Senator Deeds.
You're not here.
Not present.
Ayes 7, no 0.
Okay, 7-0 as amended. Good work.
All right, thank you, Mr. Chair. I have another bill, Senate Bill 483, which does two things. First, it eliminates the current statute of limitations for civil actions for child sexual abuse. Second, it puts requirements in place for youth competitive sports to prevent and respond to child abuse and neglect by including required background checks, the creation of a policy and procedure for responding to child abuse and neglect, and minimum annual training for any paid staff or volunteers directly working with minor athletes. I have two people here who have been working on this bill who I believe want to testify.
Okay, hold on,
Oh, yes, there is a substitute. I apologize.
okay, we have a substitute.
I got one.
Okay, we have a motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay, substitute's adopted.
Yep. So I just explained the bill, and I think there are two people who would like to speak to it in favor of it.
Okay, if you can come forward.
Good morning, Chairman and the members of the subcommittee. My name is Fatima Smith, and I'm an advocate and prevention educator in the domestic and sexual violence field for 15 years. I'm also a former competitive cheerleader who was sexually assaulted by my former coach. I sit before you as a mother who doesn't want her child to survive sports, but rather thrive in sports. I'm urging you to vote yes to SB 483 because this bill will make youth sports safer in Virginia. When parents hear my story, they often reply with, "I would never let that happen. I'm always around." Or, "That wouldn't happen to my child because my child tells me everything." And lastly, "That would never happen because my child's team has a zero tolerance policy on that kind of thing." The sad reality is, often, it's not a matter of watching your child closely enough or whether or not your child trusts you enough, but really it's the lack of policies and procedures that make it so that sports organizations become a breeding ground for predators. As an advocate and educator, I have felt many sports teams have statements that say sexual harassment and abuse are not tolerated, but they do not have procedures in place to properly intervene and/or respond to sexual abuse. We would like to think that people who are engaging in activities with youth are doing it for all the right reasons, but long gone are the days where we can rely on the notion of people having good intentions. It is imperative that we have legislation that prioritizes the safety of children in the Commonwealth. SB 483 not only provides training on how to recognize, intervene, and respond to sexual abuse, but it also ensures that there are policies and procedures established and implemented by coaches, staff, and volunteers to properly respond and intervene, which also includes conducting background checks. Another factor in this legislation is ensuring that parents and caregivers are made of these policies. And while this legislation is important to create a safer youth sports, it's imperative to know that the only person that can stop sexual assault is the predator. So much as I would like to think that one piece of legislation is going to stop sexual abuse against children, it's just really one of many things we can do as a community. It is for this very reason that we stand before you and advocate for the elimination of statute of limitations for civil claims of child sexual abuse. The research shows that the average age of disclosure for child sexual abuse is actually 53 years old. And currently, Virginia statutes don't reflect the research of trauma and being survivor-centered. For every one survivor that is not believed or does not have the opportunity to share, it creates 5 more victims. This was the case for my former coach. 2 cheerleaders came forward in 2001, and they were not believed. Fast forward 10 years, this same coach was charged with over 10 felonies involving cheerleaders, and he's currently serving over 20 years in prison. My inability to press charges when I was ready at the age of 23 was devastating. And SB 483 provides an opportunity for a survivor to seek legal justice and continue in their healing journey. It really doesn't matter when you tell, it just matters that it happened, and it should have never happened. I urge you to vote yes to SB 483. Thank you for your consideration.
Yes, ma'am.
I also want to read a statement from somebody who's not here.
But prefer you not. If you have it, we can distribute it, but I don't typically have people read statements.
Okay.
Yes, ma'am.
Good morning, Chairman and members of the subcommittee. My name is Abby Phillips.
I have been a court-appointed special advocate for neglected and abused children for 14 years. I'm also a survivor of child sexual abuse and a mother of a young child. Around when I turned 13 years old, I was sexually abused by my karate teacher, and it was about 17 before I disclosed to anyone. This man was trusted in my community by my parents and by me. He ran a small karate dojo in the building behind his home where he lived with his wife and 4 children. He abused me between the 4 and 6 p.m. class one summer evening after my parents dropped me off. The karate studio grew, and it moved to operate out of a church, but he continued to abuse children and young adults. Many of us think we would see the red flags in an abuser, but abusers groom their victims, and in many cases, they also groom the victim's parents. When I first disclosed my abuse, it was to a friend who told my parents years later. My parents experienced their own shock, pain, and sadness when they learned of my abuse. They tried to seek help and get advice on what to do. They even consulted a detective. But in the end, we didn't report my abuse to the police or to any authority. When a child is abused by someone who is trusted by your family, parents and guardians can feel trauma themselves, shame and confusion, and often don't know what to do. This is part of why it's so critical for youth sports operations to have required policy and procedures in place for reporting child abuse. Parents, coaches, and volunteers should have clear procedures to follow to report child abuse. When I was an adult, I found out my story was sadly not unique. There were other students in my karate class who were also abused. It was over 20 years before I was able to speak publicly about my abuse. When I reported my abuse to the police, sadly, the statute of limitations for criminal charges had passed. At the time, I did not know that civil action was even an option. There should be no legal limit for telling the truth about abuse. Survivors need time to process psychological and physical trauma. Please give them more time by eliminating the statute of limitations for civil action for child sexual abuse. Thank you for your time and consideration.
Thank you very much.
2 questions of the patron, please, sir.
Okay, any other witnesses in favor of this bill?
Mr. Chairman,
Okay, I've got one other.
Mr. Chairman, committee, thank you for having us here today. I'm Abby Ferris Rogers, and I'm the CEO of the YMCA of Greater Richmond, and I represent the 27 YMCAs from across the state of Virginia. And we are here in support of this bill today. The YMCA has been a leader in this area on child sexual abuse prevention, and we continue to have that as a #1 priority for our organizations. And so we just want to say that this is important and that according to Child Help, anywhere from 2 to 8% of youth athletes will experience child sexual abuse in their sports, and this is unacceptable. So we would like you to support this bill today.
Thank you.
Thank you.
Senator Servo.
Thank you, Mr. Chairman. I had first of all, no matter what we do, there's something we need to fix on this. The statute of limitations piece is drafted, I think, is probably unconstitutional.
All right, why don't we, before we get into commentary, let's just get through all the speakers.
I thought we were done with that. Oh,
We
okay,
have
never
more.
mind, I'm sorry.
Is there any other speakers?
There are 2 speakers here virtually, Mr. Chair.
Okay. Go ahead and put them through then.
Catherine Robb, please unmute and begin your testimony.
Thank you, Chairman Peterson and committee members, for allowing me to testify in support of Senate Bill 483. My name is Catherine Robb. I'm the executive director of a national organization called Child U.S. Advocacy. I am also a survivor of child sexual abuse. Senate Bill 483 will help identify hidden child predators and institutions that endanger children, hold them accountable, and also incentivize greater child protection. Presently, the data tells us that 1 in 5 and 1 in 5 girls and 1 in 13 boys will be sexually assaulted, often repeatedly, before their 18th birthday. Most abuse happens by someone the child knows. Stranger danger is considerably less common. Without accountability, the children of Virginia remain at great risk. Presently, across the country, 17 jurisdictions have eliminated the statute of limitations for child sexual abuse. 27 jurisdictions have enacted revival or window legislation. 3 jurisdictions have enacted permanent wide open windows. This year alone, as of January 19th, 19 states and the federal government have introduced new statute of limitation reform for child sexual abuse. 11 of those have revival windows. Delayed disclosure science supports this amendment. It provides child sexual abuse victims the opportunity to seek compensation. We all know and understand the trauma of child sexual abuse. It's devastating. It lasts a lifetime. Post-traumatic stress, impaired social, emotional, cognitive development. The list goes on and on. Just compensation for child sexual abuse survivors will shift the cost, the significant cost of abuse from the victim and society and the Commonwealth of Virginia to those that caused it, the bad guys, because child sexual abuse in our society is epidemic and it generates just staggering costs, whether it's healthcare, education. I just have one final point, if I may. Yes, thank you so much. Many will argue that this is not fair, that due process, that we don't do this for other torts. So to all the attorneys on this committee, my response is we are not talking about a slip and fall case. We are not talking about a fender-bender case or breach of contract. We are talking about the rape, sodomy, and sexual assault of children. We also have safety nets, the rules of evidence, as we know, the rules of civil procedure. Plaintiffs must prove their case.
Okay, we don't need a lecture on civil evidence, ma'am. Just let's get.
Thank you. I just want to, these arguments come up, and I mean no disrespect.
No,
Chair.
not at all. We need to move this.
Of course.
Yes.
So
Thank you, Ms. Rouse.
My final point is just this, if I may. The law and public policy demand a completely different response to this epidemic. I thank you for your time.
Thank you. Next.
Lori Tasharki, would you please unmute and begin your testimony?
Yes, thank you for letting us speak. My name is Lori Tusharsky. I'm the Director of Institutional Abuse Prevention at Stop It Now, SCAN of Northern Virginia, which is a survivor-led organization and calls for minimum levels of training for adults working with children in sports settings. As child advocates, our sole responsibility is to put children at the center of everything we do. We do not only support, but need passage of this bill as a nonpartisan action to prioritize the safety of children in the Commonwealth. This is an opportunity to back up our values and beliefs with action. As a community, we say that child safety is paramount. Leading research tells us children who experience harm in organizations have more adverse impacts in adulthood. The annual debt to child sexual abuse alone is over $800,000 per child per year. We know that all adults are responsible for keeping children safe, so let's back up those.
$800,000 per year?
Yes, sir.
Per child?
Per child. We know that all adults are responsible for keeping children safe, and we want to back up those beliefs with actions and pass this bill. 90% of child sexual abuse, as the other speakers have said, is perpetrated by someone known and close to the child. And right now, child protection professionals consider competitive sports leagues as a high-risk activity for emotional, physical, and sexual abuse. Athletics should improve every aspect of a child's safe, healthy development. It should not cause lifelong impacts to their health and well-being. And finally, those who work with children should expect that privilege comes with an obligation to keep children safe, to maintain professional boundaries, and behave in ways that don't make children more susceptible to abuse elsewhere. So our obligation to know, identify, and report signs of abuse within a program or organization allows these individuals to be trusted adults who know how to respond when a child discloses harm by another child or action or adult. Thank you so much for your time today.
Thank you, ma'am.
Carrie Silverman, please unmute and begin your testimony.
Hi, good morning. My name is Carrie Silverman. I'm here actually to testify, to express concerns on the bill. Is this the appropriate time to do so?
Yes, sure. Go ahead.
Okay. Thank you, Mr. Chairman. Again, my name is Carrie Silverman. I'm here on behalf of the American Tort Reform Association to express our concerns regarding SB 483 in its current form. ATRA is a national organization of nonprofits, small and large companies, as well as state and national trade and business groups that supports a civil justice system that is fair and predictable. We appreciate the committees and the sponsors' work to support survivors of childhood sexual abuse and addressing this difficult issue, and the advocacy of the courage of the proponents of the bill. I'm an attorney and counsel to ATRA. I don't represent defendants in these cases. My testimony is about general principles of statutes of limitations and why they're important. What we're concerned about is a portion of the bill that completely eliminates a civil statute of limitations and would retroactively revive negligence claims against organizations that would date back decades and the precedent that would set for other kinds of claims. Statutes of limitations really are a core part of a properly functioning civil justice system. Some might view them as an arbitrary time limit. Others might view them as a way to avoid liability on a technicality. But the core reason we have statutes of limitations, which shouldn't be overlooked, is to allow judges and to allow juries to make decisions about liability based on when the best evidence is available, when witnesses can testify, when records are there, when memories are fresh. And for every type of civil claim, there's a civil statute of limitations that typically provides a finite time to sue, and changes are usually made prospectively. And we have no issue, ATRA has no issue with providing survivors of childhood sexual abuse with a lengthy, maybe a very lengthy period to file a claim. Our concern with the approach that's taken in this bill is that there's no limit at all, which is compounded by a reviver that will allow claims to be filed today based on allegations of conduct that occurred many years ago. In cases against private and nonprofit organizations that serve children, the perpetrator will often be dead. The employees that worked at the organization will be gone. Any records will have long been discarded. The ownership and management of the company may have changed. How will the daycare center or school or youth club or sports program respond to a lawsuit in 2023 based on something that occurred in 1953? What steps an organization should have taken when hiring or supervising employers or volunteers is going to be looked at in hindsight.
Okay, Mr. Silverman, can you please wrap up? And I'm not being disrespectful because I understand your points, but we just need to move this along.
Yes.
And this is a subcommittee.
Thank you, Mr. Chairman. I'll wrap up. We're also very concerned about the precedent this sets for other claims. I'm not talking about slip and falls, as Ms. Robb had noted. We're talking about cases where people were exposed to toxic chemicals, all kinds of tragic cases. This child sexual abuse is horrific and horrible, but the tort law typically does involve really horrible situations. And if we go down this path here today, we're worried about what comes next. So there's significant constitutional concerns here, which I won't get into.
Okay.
I thank you for your time.
Thank you, sir. All right. Let me ask you, Senator McClellan, I'm looking at this bill, and it puts a significant burden on coaches and anyone who volunteers in youth athletic. Has there been any attempt? I don't hear anyone speaking in this audience who's a coach or who's actually going to be, well, believe me, I'm a coach and I'm going to talk about it.
I've done it too.
Does anyone know, for example, to coach football, what you have to do right now to coach football under the United States Football Association? Anybody know? You have to take a day-long class in concussions, in providing water, in proper tackling techniques, in proper how to put your helmet on. You have to, it's literally a day long. And then you have to go through all the same, checks. That's for football. There's similar programs for soccer, for basketball. Any youth coach, you have to go through this. So we're going to add more time to coaches. I don't see anybody from the coaching associations that's being brought into this conversation, and yet they're the ones that are going to get 100% of this burden. Is anyone here from a coaching association?
Mr.
Okay, so having established that, let me just, I want to make a point because, and I've represented, by the way, plaintiffs against sports leagues where the sports leagues were negligent. I have a case right now in Fauquier County, which the facts would blow the roof off this building. And I appreciate the advocates because for too long we never discussed this issue. Having said that, I will say that for every negative incident that happens, I think there's 100, maybe 1,000 positive incidents. And I'll give you an example. I coached youth football for years, and the kids that play football are a different demographic. Oftentimes, their parents don't have cars. They have to get to practice. And myself and my co-coach would go and pick people up at their apartment and bring them to practice. And we would meet the parents and do that. Now, if you pick up a child and bring them to practice or take them to a game, you're presumptively an abuser. And you got to take 4 hours of, quote, evidence-based training on not abusing children. Well, I can tell you the chance for those children to participate in athletic leagues is life-saving. And if you put all these restrictions in place, people like myself, they're just not going to do it. I mean, my own kids can do whatever, but you're going to basically disincentivize people to coach. And it's so hard right now to get coaches. And if you're just going to treat them as potential abusers, which is kind of what this statute does, youth sports leagues are going to fold, unless for wealthy kids, because, whatever, that's not a problem for them. I just feel like this statute is going to be devastating to youth sports leagues, and nobody is speaking on their behalf.
Mr. Chairman.
Mr. Senator Obenshain.
To the youth sports league, I mean, another way of addressing the issue that you're pointing out is, number one, we have no criminal statute of limitations for felony sex offenses that occur, and that's important. We want to make sure that these people are put under the jail, and nobody here is going to dispute that. But just consider what happens, and I'm worried about the innocent person who's accused. Some coach who coached in 1985 a youth sports league, and all of a sudden in 2020 or 2022 is accused of an unspeakable offense during one of these practices. How does that person track down the folks who might be witnesses? I mean, the due process issues are really significant, and I would never defend these people, but we've got to worry about the innocent person. And when I look at these bills, I know that the children are innocent, and thankfully we've got our criminal process that is available to pursue these folks. But the due process issues of having to defend yourself, your home, and everything that you've accumulated for your entire life is, it's a pretty stunning burden.
Mr. Chair.
Senator Boysko.
Thank you. I would like to just harken back to the two people who were speaking as victims of childhood sexual assault by their coaches. It is extraordinarily difficult to speak up and stand up for yourself when that has happened to you. There is absolutely the conversation that my good friend from Shenandoah just talked about, where someone 20 years later brings this up and claims, so-and-so did this to me when I was 12. That doesn't happen. What does happen is the victim is quite often told by their parents, we don't want to rock the boat, hush, it's okay, you didn't understand what was happening. And then later, when she is an adult and realizes that actually he was raping her or doing something else to her, that doesn't happen until a person is able to actually own their space. And that happens a long time after it happens. I understand your concerns about protecting people and making sure that we have coaches, but my interest is in making sure that our kids have a safe place to grow up and to experience a sport together around adults who are going to treat them without assaulting them. And we know, look at Larry Nassar in the swimming world in the DC area. There was a perpetrator who had abused numerous kids, and everybody just kind of shushed it. People knew about it. You look at the football team in Pennsylvania. This happens. Let's be real clear about this. And I think that the senator's idea here has a lot of merit. Thank you.
Mr. Chair.
Mr. Chair.
Mr. Chair.
Senator Edwards.
Over 10 years ago, we made it 20-year statute of limitations. I remember I chaired the Civil Law Subcommittee at the time. We spent a lot of time on the issue, but we agreed to 20-year statute of limitations. And how does that fit into what we're?
Well, we would get rid of that.
Senator McClellan, how does that fit into what we did 20 years ago, over 10 years ago, about 20?
10 years ago, we made it a 20-year statute of
Mr.
limitations.
Chairman.
Well,
Okay, Senator Servell.
First of all, a big part of this bill is unconstitutional as drafted, and I think if we would correctly draft it, it might alleviate a lot of the concern. But, I'm sure it was unintentional, but when I litigated a case to the Supreme Court of Virginia about organizations and retroactive liability under the Constitution. You can't do it for organizations, only natural persons. And anyway, that I think would solve some of the dilemma, but I agree the bill has bigger problems than that. And I'm not sure how much more we need to work on.
Okay, Senator Norman.
Thank you, Mr. Chairman. Senator McClellan, going down to line 417, a two-part question. It indicates that it shall not apply to local government. So does that exemption apply to the Williamsburg-James City County Community Rec League that's run by those two municipalities?
if it is a municipal league, then you'd be correct.
Okay. Mr. Chairman, my
Senator Norman.
second and final question. What about church leagues?
If it is a church league that is run by a private school, it would fall within the exemption. If it is not, it would not.
Mr. Chairman, not my question. My question is that some churches sponsor sport leagues. So my question is, are they encompassed in this bill?
Yes.
Okay, thank you so much.
Let me just make one last point, and then the chair will entertain a motion.
Can I make a
Oh,
point?
please, Senator McClellan.
So this bill does two things. And if we can fix the first part and the second part needs work, I think the first part is at least worth continuing to move forward. So let me talk about the statute of limitations. I'm open to an amendment to conform the civil liability statute of limitations to what we did 2 years ago for the criminal statute of limitations. What we did 2 years ago was for a criminal offense, you had up to 5 years after the child reached majority, because this body recognized, as our witnesses testified, and as Senator Boysko said, that sometimes you have to deal with the extraordinary psychological and in some cases physical trauma, which in some cases children suppress, before you are able to seek criminal liability. And yet, if the statute of limitations has run for civil liability, you may get criminal liability, but all of the payment and the burden of dealing with the trauma psychologically and physically falls on the victim. So at a minimum, and that's consistent with what at least 4 or 5 other states do. At a minimum, I think this bill should do that. We've worked extraordinarily hard on the second part with the training and the background checks to strike the right balance.
With whom?
With a number of organizations, coach, we don't have coaches here today, but let me finish, Mr. Chair. We have worked extraordinarily hard to strike the right balance. If we need more time to strike the right balance on the training and the background, I'm happy to continue working on that going forward for another bill next year. But at a minimum, I think we need to conform the statute of limitations for civil liability to what it is for criminal liability, so that these victims have the same amount of time to prepare themselves to come forward with allegations against their abuser and be able to get both criminal justice and civil justice.
Okay, and I appreciate that. And don't mistake, this is a legislative give and take, and Senator McClellan is a fabulous legislator. I speak from the position of one that has tried to coach and how hard it is to comply with all the requirements you have now. And let me give you an example. You talk about 2 hours of evidence-based training simply to be a volunteer if you're alone with, in control of, or supervising children. Well, I've helped out on various teams where I might supervise a practice because the head coach couldn't get home from work in time. Or I might be in a situation where you're at the practice field and it's starting to rain and kids are there alone without children and they need someone to give them a ride home or give them a ride to a safe place. And are you going to take 2 hours of evidence-based training? Who's going to take care of that child? And a lot of these restrictions are just, they're not practical, they're not reasonable, and frankly, you know, we've treated children pretty badly in the last 2 years, and shutting down youth athletics, which is what this legislation would do as currently written, is not the answer. It's just not the answer, folks. So I admire the intent, and on the statute of limitations piece, I think we may be able to handle that, but I'll tell you, just airdropping this into the code on telling people how to coach when they already have so many restrictions on them right now, not to mention negligence laws, would really be extraordinary.
Not many.
Okay.
Mr. Chair, I would move the amendment that Senator McClellan suggested in concept.
Okay, can someone state what that amendment is? I didn't, I'm sorry.
Mr. Chairman,
Please state the amendment.
on line 51, after an action, insert when the sexual abuse was committed by a natural person. And that's because in the Constitution right now, the General Assembly is limited in applying statutes of limitations retroactively unless it's against a natural person for sexual abuse.
I
think that's right.
Where's Surabel? I'm sorry,
He's proxied out.
That's
Oh.
basically the amendment he suggested.
All right, why don't we do this, and let's adopt this amendment and carry this over. Jen, I'm happy to talk with you one-on-one. I just feel like I said, the coaching issue, that to me is what my big concern is, the statute of limitations. We did have a fight over this a few years ago. But why don't we just go ahead and adopt the amendment and carry this over for a week? Okay. Does anybody have a problem with that? Yeah, I get the feeling. Okay, all right. Why don't we adopt, motion to adopt the amendment, all in favor say aye.
Aye.
All right, and I will carry this over for a week.
Thank you, Mr. Chair.
And Jim, let's talk one-on-one.
Thank you, Mr. Chair.
And I want to thank everybody for coming and participating. Thank you very much. Okay, do we have any other patrons present?
Mr. Chair, there's just two from Senator Obenshain, and the last one is yours.
Okay, Mark, you want to go next?
I have two. Oh, pardon me, the other was rolled.
Can I do that from here? Sure. Do you mind? Mr. Chair?
Yeah, go ahead. That's fine.
Senate Bill 694 is one of our annual eminent domain cleanup bills. This is one of the more complicated areas of law, and every year we wind up looking at a number of issues that have arisen that really need to be fixed. And this does several things. Number one, it requires, in recent years, we have required payment of interest during the eminent domain process, but when funds are paid into court, they are often put in non-interest-bearing accounts, and this simply requires that when it is paid into court, that funds be placed into interest-bearing accounts. Second, survey costs. We have a provision in current code limiting survey costs that are reimbursed to $1,000. And this is one of these issues where time passes, the cost goes up, but we never address that increased cost. We've spent a lot of time talking about trusting the judges this year. This simply says that rather, it takes out the $1,000 and says that courts have the discretion to award reasonable costs and fees for a survey. It also requires, it has provision concerning the form of title reports, requiring a 60-year title report, which is pretty standard, and the attachment of the documents, the transfer documents. It also provides that a limit on, well, not a limit, but it addresses the length of a construction easement And right now, it's open-ended very often. The landowner doesn't receive notification of when it's ended. And this simply requires a notice of the termination of the temporary construction easement. It also addresses cases where land is condemned in connection with some future development project, not to convey to a private party, but for example, a road improvement. And very often there is a delay in seeking a permit for the construction, which artificially decreases the property value of the condemnee's property, and it prohibits localities from intentionally delaying that process in order to keep the award down artificially. And it also sets forth a process for moving condemnation forward in cases where the condemnor just files the condemnation action and sits on it. Sometimes it's in the interest of the condemnee to move it forward, and this establishes a process. I have Josh Baker, who is a prominent Virginia condemnation lawyer, on the line in the event that anybody has questions that are more complicated than I am able to answer.
Okay.
And Mr. Chair.
Yes, go ahead, Senator.
Finally, we have been talking with a number of the utilities. The issue dealing with certificates of take are not intended to address utilities. And I believe that there is a line amendment that maybe Mr. Nolan has that I would like to offer in order to clarify the intent.
Yep, Mr. Chairman, Chris Nolan with McGraw Woods on behalf of Dominion Energy and in consultation with Mr. Baker at the firm of Waldo and Lyle. Kristen has the amendment, but I can read it into you now. It's line 199. It says, was acquired. After the word acquired, insert by certificate. And then the second amendment there would be line 197 to strike the code reference, the new code reference of 25.1422, and insert 25.1319. And what the
So it would be 319 would be the code?
Correct. And the effect of that is to tweak this section to not apply to condemnors without the quick take power.
Mr. Chairman, I move that amendment.
All right, we have a motion and a second to move that amendment. All in favor say aye. Aye. Any opposed? Okay, so that amendment's before us.
And, Mr. Chairman, the second amendment discussed with Josh, Senator, was with regard to the survey, as opposed to striking the amount, understanding that there is inflation and the court should have that discretion, would offer for the committee's consideration on line 107 after the new language of cost and fees to consider inserting comma not to exceed $7,500 comma unless the court approves a higher amount.
I move that amendment.
Okay, the motion been seconded. Can you restate that very quickly? That was on line, which line?
107, I believe, after the word fees.
Yep.
It would say, comma, not to exceed $7,500, comma, unless the court approves a higher amount.
Not to exceed 7,500. And these are costs and fees from what?
For the survey, comma, unless the court approves a higher amount. So that gives the escape valve for the court if there's a large parcel that costs more, but also put some certainty into it as we currently have.
All right, so we've got a motion and a second to adopt that amendment. All in favor say aye.
Aye.
All right, so that puts a $7,500 cap on the owner's ability to recover costs and fees.
Unless the court finds reason to exceed that.
Correct.
Okay, all right. And just a question, I do this practice, would this be automatic for the landowner to get their own appraisal? Yes, no?
Well, Mr. Chairman, I believe that the new language changes it from at the court's discretion to shall order the condemnor to pay up to that amount.
So let me just walk through this. If, let's say, I own a raw acre of land off Route 28 in Fairfax County, and VDOT is expanding Route 28, and they're going to take half my land, and maybe the land's valued at $500,000, and they present an appraisal saying, okay, we'll pay you $300,000. And I go to Chap Peterson or whomever, Josh Baker, and we say, okay, we're going to get our own appraisal. And we get our own appraisal.
Survey, not appraisal.
Survey.
Correct.
Oh, so this is not appraisal.
This is only the survey.
Right.
Ah, okay. Oh, so that's not so helpful. Okay, all right.
See,
Doesn't really
this
do
is
anything,
modest,
okay.
modest little
Yeah,
bill.
this is incredibly modest, folks. I thought this was actually substantive. Okay, all right. All right, Obenchain, is that it?
That is it.
Thank you.
Okay. All right.
I would ask Mr. Baker to testify unless there are questions raised by the opposition, just in the interest of time. I think Mr.
Oh, we have
Flynn
somebody
may
here.
be here.
Come forward, sir. Come forward, sir. Are you in support or opposition?
Good morning, Mark Flynn on behalf of the Municipal League, and we have problems with the bill. Some pieces are fine. I will say that on the, even on the survey part where it is currently discretionary for the court, this makes it mandatory, and in a town's case or a city's case, they may need to take a lot out of a subdivision. There's been a recent survey, it's a fairly recent subdivision, need to acquire it. And another survey there would serve no purpose. But the major issue with it is that this pretty much requires the condemnor to pay all of the costs of the condemnee in every condemnation.
Right.
Well, as you all know, there's really a balance between, especially towns and cities that tend to not want to do condemnation. They tend to negotiate more with the landowners than the state, and I can't speak on behalf of the state. But in any event, there's a negotiation, and and everybody wants to get as much as possible for his or her property. In most cases, the town or city is going to have an appraisal done, and that has to be made available to the condemnee. And when a condemnee, a person who owns the property is being reasonable, they'll say, okay, yeah, that's great. Well, this bill, I think, removes some of the incentives for somebody to be reasonable in negotiations with the city, because if I'm the landowner, I'm not going to have any costs of the litigation because the condemnor is going to pay for it all. And that's the problem we have with it. But again, certain provisions of it are I think, really great.
Okay, I see kind of reading through two substantive issues here. First of all, are the clerks here on the interest of the, are here on the issue of the interest-bearing account? Do they have, because we already have interest-bearing accounts for the money that's held in trust. Is that not statewide?
It is not.
Okay, do
Some
the clerks have a
do
position
not
on that?
Put it in interest-bearing accounts.
Okay, so basically, if somebody condemns your land, they have to put up the money once they file the certificate of take, and it will sit in an interest-bearing account.
That's great.
The second part is, you are allowed as an owner to draw down the money. You file what's called a drawdown petition, and 99 times out of 100, you'll get an attorney to do that for you. It's a very simple process. I typically do it for free. I probably shouldn't have said that, but, if for a client. So I would be a little bit reticent to actually having the attorney compensated for a drawdown petition, because frankly, it's something we do gratis. I don't know, what are your
I don't
thoughts on
think
that?
we're messing with that.
No, we're adding language on 180 and 181. The authorized condemnor shall reimburse the owner for his fees and costs, including filing fees and attorney's fees incurred in filing the petition. I thought that was the petition to draw down the money. Am I wrong? That's new language.
I mean, I think it shifts attorney's fees to the city or town, yeah. And then on lines
Okay.
184 through 192, it also shifts appraisals and experts that the landowner would would hire, the locality has to pay for that too. And that's my point about it removes the incentive that a landowner has to come up to a reasonable deal with the locality.
So they would have to pay for the cost of the appraisal. I did have
Yes,
that right.
yes, sir.
Okay, I thought that would.
Those are the provisions that we have. The interest-bearing thing, I think that's fair. Don't know about the logistics.
Okay, and then that's how we do it currently in Northern Virginia. Okay.
Mr. Chair?
Yes,
Just a
Senator Boysko.
Question. So who currently pays for those things that you're shifting over to the
It's-
municipality now?
Landowner.
The landowner pays,
Whose
yes.
land is being taken.
Think of it this way, before you can take land in Virginia, the condemning authority, whether it's VDOT or the county, has to present you with an appraisal for the fair market value. That's on them.
Yeah.
And typically, if it's a large, you'll go and get your own appraisal. And so this would require VDOT to pay for their own, the landowner's appraisal. So they're paying for two appraisals.
Yes.
But the landowner, but for VDOT coming in and taking their land, they wouldn't have any expenses whatsoever. So
That's a
why
fair
shouldn't
point.
they?
Well, and there's a method of recovery right now, isn't there? If you get above a certain amount at trial, then you do get your costs paid?
Yeah, but you're still having your property taken. And, I understand that, and what Mark is an old friend, but I understand that, that government has, screws that they can tighten on property owners. And, that is one of the levers. I mean, he's exactly right, but it's financial pressure on somebody whose property is being taken from them, without their permission.
Okay. Mark, can you answer my question on lines 180 and 182 about the authorized condemned nor shall reimburse the owner for fees and costs, including filing fees and attorney's fees incurred in filing the owner's petition? Which petition? Is that the drawdown petition?
I got to phone a friend.
Okay. Josh, are you out there?
I am. Good morning. I don't know if you can see me here.
Yep, we got you. Speak to us.
Good morning, Chairman and members of the committee. Yeah, I'll address that first, Senator Peterson. That was intended to address the fees, the attorney's fees that are charged by lenders when you have to go through the certificate of release process. Many times these properties are encumbered by a mortgage. There's a lender involved. The lender has to sign off on things, and they very often have a pass-through charge for their internal attorneys to handle that. This is not meant for landowner's attorney. So I'd offer this as a change there on 181 after it says attorney fees, a simple inclusion, perhaps charged by a lien holder or something along those lines. May help clarify that. That was the intent.
I move that.
All right, I'll second that. So it's be after fees and costs charged by a lien holder, so not the owner or the VDOT. Okay, we have a motion and a second to adopt that amendment. All in favor, say aye. Aye. Any opposed? No. Okay, so we adopt that amendment. All right, keep going, Josh.
Sure. Let me speak a little bit to this idea on the appraisals. Senator Peterson, the $7,500 cap, that is just for survey work. That's not for appraisals. The other section that I think...
And it's limited by reasonableness, correct?
Yes.
Even 7,500. So if a court says your $6,000 bill is unreasonable, they can award less.
I believe that's the language that's been now agreed to in the amendment. But moving to the reimbursement for appraisals, I think this was framed by the gentleman speaking against as a position where an owner is unreasonable. Well, let me talk to you about that. Very often, the owner of the property that's being taken for a public use that we're all going to use is presented with an appraisal that flatly ignores an entire column of just compensation required in our Virginia Constitution, and that's the damages component. I've been doing this 15 years exclusively. I've probably seen 10 appraisals in that time where the condemnor shows up and says, yes, we're actually damaging your property. And that's what these cases are usually litigated about, is what is the damage going on? So what happens is this owner's presented with that appraisal, doesn't have anything to say about damage to the property, maybe gets the actual real estate values right, but the owner has then said, well, look, if you don't like this, come back to us with your own numbers. An owner does that on their own, kind of looks at the marketplace, comes back and says, look, I think you're also hurting my property by, X number of dollars. They're immediately told, okay, well, where is your appraisal report that supports that? And very often they don't have one because these reports cost a pretty good amount of money. On the low end, you're looking at $2,500 for an eminent domain appraisal report. If it's a commercial property, then it's going to be $10,000, $20,000, depends. But where this is most important, and the folks who suffer the most from this, is not the big corporations who can go out and get their own appraisals. It's the folks with a home or maybe a farm where the road project or the utility project, but here we're talking about road projects, is going to do significant damage to their home. And it's the case right now that folks will have to give up just compensation because they're not equipped with that appraisal. So I'm happy to answer Senator Obenshain if there's any other questions from the subcommittee.
All right.
Happy to address those.
All right, why don't we do this? We got to move this quickly. I've got the chairman or co-chairman kind of whispering in my ear here to move this along. So is there anyone else that has a testimony on this bill? And then I'm going to make a motion. Okay, anyone else with testimony? All right, let me make a motion, and Josh, you can beat me up at a later time. I'm going to take out lines 183 to 196, which is basically the appraisal and having VDOT pay for the appraisal. VDOT or the county already pays for an appraisal, and I think what you're doing is basically requiring them to pay for 2 appraisals. I just think that's not a bridge I'm ready to cross at this point. We do require them to pay for an appraisal now, and I don't want to, at this point, admit that it's always one-sided. Sometimes they can be pretty fair. So I would move that we just take out lines 183 through 196, which is the dual appraisal. If I can get a second on that. All right, so I've got a motion and a second to take out lines 183 to 196. All in favor of that amendment, say aye. Aye. Any opposed? No. Okay, I got 2 noes. All right, call the roll. Or Mark, do you want to speak to it?
No. I'm just counting these noes.
Okay, that's fine. We got 2 noes.
Senator Obenshain and
Okay, remove to report. I have a motion to report as amended.
Second.
Motion to report as amended. And clerk, call the roll.
Senator Lucas. Aye. Senator Norman. Aye. Senator Obenshain. Aye. Senator Boysko. Aye. Senator Serville. Aye. Senator Peterson.
Aye.
Senator Edwards.
Aye.
Senator Deeds. Aye. Ayes 8, noes 0.
Okay, so that bill is, we recommend reporting as amended. That was Obenshain's bill. All right, let me get to my bill, which is Senate Bill 666, which I know caused a lot of consternation. And let me make 2 amendments, or offer 2 amendments. First of all, what I would do is on the lost profits section, which is lines 33 down to 49, I would put back in the 3-year cap. In other words, you get a 3-year look back on lost profits. That's currently the law. It's been the law. And so I would make a motion to put in the 3-year cap on lost profits, if I can get a second. I got a motion and a second. All in favor to that, say aye. Aye. Okay. Secondly, I'm going to basically keep the lost access as is. I've heard from a lot of people, and I'm just not prepared to change that right now. I think that's just a bigger struggle than what I've got, and maybe it's the title of this bill is 666 kind of spooked me. So I'm going to make a motion that we keep the lost access language as is, if I can get a second. Okay, I got a second. All in favor, say aye. Aye. Okay, now that gets to the heat of the meat of the bill. And let me just speak from the desk here. The statute for lost profits, I voted against it when we passed it in 2012. I think myself and Deeds were the only Democrats that supported the constitutional amendment on eminent domain, but I did vote against the lost profits bill. And the reason why is it was in my opinion, discriminatory against small business, and let me explain why. The way it's written right now, it basically sets up lost profits as what is determined by the last 3 tax returns. The problem with that is that if you're a small business, an LLC, a PC, typically the money that flows through your business, you will take out on the front end as income. You'll take it out as rent in some cases if you own the land. You will very rarely report it all as a profit to you in your own small business if it's a family-owned business, which meant that if you are harmed by a project and your business shuts down, you may be helpless because you don't have previous years showing you as a profitable business, even if you and your wife were taking a couple $100,000 in income every year. And I just think that we need to simplify the language and leave it more flexible for juries and judges to get this right. They do lost profit analysis all the time, and they can do it. So I would like to keep the lost profits language. Senator Servell. That's all I have to say.
Yeah, Mr. Chairman, I think with the 3-year cap added back in, I think that's the balance that was in the original bill, and I think we need to, or the language, I think we need to leave that. And I cannot agree with you more about tax returns as being the improper way to measure lost profit. I've had that exact scenario in cases I've litigated where people are actually making money, but the tax return shows 0 because they're paying themselves salaries, and that's not a fair way to look at it at all. I agree with you 100%.
Okay, thank you for that. Anybody else have a comment? Okay. Josh Baker, Mr. Baker.
Senator Peterson and subcommittee, I would request that you come back and reinstall that lost access language. This is a major issue that affects owners of every property type. That is a very important protection for property owners who are losing access to their property. Current language has proven to be a morass of kind of unworkability, and we'd request that you take that back under consideration in this subcommittee.
Well, let me get back to the House. Okay, Josh, I appreciate that, and if I can offer speakers, I assume you're on the other side or maybe the medium side at this point.
Mr. Chairman, again, Mark Flynn, Municipal League, and very much appreciate the amendments that you have offered to your bill, particularly on the lost access. That the amendments, that the changes that this bill create, you can have a new intersection coming in that's going to be a major highway coming to your property, but your access is messed up a little bit temporarily, and even though you're going to be in a much better position and see benefit from it, the original bill would have had the locality pay for that. We think that's an issue. And Mr. Chairman, I would say on line 104, 105, there's language stricken compensation for loss, and this is profits, I think profits and access, shall not be duplicated in the compensation otherwise awarded to the owner. And it seems that ought to stay in, because if there's if the compensation actually compensates otherwise, if this is stricken, it could end up having a double recovery.
Okay.
I'd like to have you consider that anyway.
All right. If somebody wants to make, I don't have a firm opinion on that either way. I think typically you have 2 pots of recovery. You've got lost profits, and then you've got the actual value of the property that's taken. So, I don't see how they would be duplicative. I just think
understood, and
I think it's unnecessary. I regard it as gratuitous. So
Okay.
You know.
Well, that's our request, and I think
Okay.
if somebody else.
Yeah.
does.
Yeah, Mr. Chairman, Chris Nolan with McGuire Woods on behalf of Dominion Energy, same concerns as Mr. Flynn, and particularly lines 104 and 105, and the deletion of the duplication language.
Compensation. Okay. Well, if there's a motion from the panel, I'll be happy to entertain it. Again, I think it's gratuitous, but. Okay. All right. I think we're going to leave it as is for now. All right. Let me just say, Josh, I hear you on the lost access, and I think, life is incremental. That's all I can tell you. And I think cleaning up the lost profit statute's a significant victory, and if we can do that, if we can get that. So anyways, Chair will entertain a motion on the bill as amended. Okay, I've got a motion to recommend. Is there a second? I got a motion and a second to recommend reporting. Clerk, call the roll.
Senator Lucas. Senator Norment. Senator Obenshain. Senator Boysko. Senator Serval. Senator Peterson.
Aye.
Senator Edwards.
Aye.
Senator Deeds. Ayes 8, no 0.
Okay, good work. Is that our last bill? Okay, 9:50. Good work, gang. Thank you. We're adjourned.